please subscribe and don't forget to press the bell icon to get notified whenever we upload a new video.
The Supreme Court today disallowed the Binani UltraTech combine to bid for the defaulting Binani Cement company. It said that UltraTech, having lost out in the bid, was now reappearing with Binani as a front company. Well, this appears to be a landmark judgment. What we are asking today is, how important is this judgment in the life of the IBC? Is this a landmark one that strengthens the IBC process for the long haul? Does the judgment strengthen the convention of the bid going to the highest bidder? Does it indicate that in general, the judicial system is determined to ensure that the IBC NCLT process doesn't get mired in judicial ambushes the way the SARFAESI Act and before it the DRT Acts got ambushed? Joining me to discuss this issue is an eminent panel: Shardul Shroff, Executive Chairman of Shardul Amarchand Mangaldas, Rajendra Chitale, Advisor, Chitale Legal, Suharsh Sinha, Senior Associate, AZB and Partners, and in a bit maybe Mr. H.P. Ranina will also be joining us. But before we go into the discussion, let us hear out our own Ashmit Kumar, our legal expert who was at the court when the judgment was delivered. Ashmit, tell us the main points of what the judge had to say.
Right, so a big setback coming in for both Binani Industries as well as UltraTech. The Apex Court dismissing the out-of-court settlement of 7,600 crore rupees, and in doing so, clearing the air on that bigger question as far as the out-of-court settlements are concerned, as far as Track 2 is concerned with respect to IBC, clearing the air on that. What the Apex Court clearly observed as of right now is that it believes that what cannot be achieved directly cannot be done indirectly either. That's the sum and substance of its observations. Let's keep in mind that Binani Industries had moved the Apex Court with their out-of-court settlement offer of 7,600 crore rupees, arguing that this will satisfy all the pending dues. This argument, however, failed to pass muster with the Apex Court. The Apex Court observed also heard arguments from Dalmia clearly saying that the sanctity of the IBC process needs to be respected, that if allowed, if this out-of-court settlement is allowed, it will open floodgates, it will reduce the number of serious bidders in resolution proceedings, it will defeat the very purpose of the IBC if the sanctity is not respected. In light of that, the Apex Court observed that this appears to be a case where what could not have been done directly is now being tried indirectly. It observed that Binani was nothing but a mere front for UltraTech, that it is a known fact that UltraTech was a bidder, it lost out, and after having lost out, it has now put up Binani as a front, as a proxy to come back through the Track 2 process, which is not allowed in the statute, which the Apex Court does not agree with, and hence as a result that relief has not been granted. It has allowed, however, Binani Industries to withdraw their applications. Binani Industries is in all likelihood will now agitate this case before the NCLT, but clearly as far as the Apex Court is concerned, shutting the doors down on out-of-court settlements on Track 2 as far as IBC is concerned. Back to you.
Ashmit, thank you very much for filling us in on the main points that the judge mentioned today. Once again, the broad question we are asking is this a landmark judgment in terms of preserving the sanctity of the highest bidder? Does it also prevent any out-of-court settlements? Does it reiterate the judicial system is determined not to allow the IBC process to go the way its predecessors, the SARFAESI Acts and the DRT Acts went? What can destabilize this process and what can be done to ensure that the IBC process remains robust and helps the banking system become more efficient? Once again, let me introduce my guests. Mr. Shardul Shroff, Rajendra Chitale, Suharsh Sinha and H.P. Ranina are with us. That's absolutely legal luminaries that I have. Mr. Shroff, first to come to you. Do you think that now the convention of the highest bidder is set and out-of-court settlements will be frowned upon? Is that a firm convention?
I would agree with you, Lata, because basically the Supreme Court in its deliberations today obviously gave that clear, unequivocal indication, and that has actually resulted in Binani Industries having to withdraw the matter rather than suffer a dismissal in the appeal that they had filed.
Okay. Would you say, therefore, that in future cases as well, out-of-court settlements will have a kind of a second-class treatment for all time? Is that discouraged, or is it only for this case?
No, I would say that, in fact, it requires a little longer explanation, and therefore, if you let me sort of spell it out, I'd be happy. What had happened was that you had a complete bid process resulting in a committee of creditors meeting approving a resolution plan by about 99.43% vote. You had the resolution professional filing that resolution plan before the National Company Law Tribunal. So this was a closed process as far as the bidding process goes. And secondly, UltraTech Limited was one of the bidders and it emerged as number 2. So they lost in the race. Now, what was then attempted was that a combination between Binani Industries and UltraTech proposed a full settlement and consequently a withdrawal of the insolvency process. Now, this was an impermissible game for the simple reason that Binani Industries Limited as a promoter was disqualified on its own under section 29EC and UltraTech was also not eligible to agitate the matter because it had lost in the bid. So a combination of two persons who were otherwise not eligible to then propound a theory that they could settle the matter, and settlement means what here? Settlement meant withdrawal of the insolvency proceedings before the NCLAT. They had today, in the hearing that took place today, they had challenged the NCLAT order, which had been obtained by the Rajputana Industries to the effect that the observations made by the Company Law Tribunal in Kolkata and the NCLAT in another matter should not come in the way or interfere with the decision making of NCLT. And therefore, Binani Industries was trying to say that no, that order should be set aside and we should be allowed to do things outside. And they had filed an application which indicated and reiterated the same plea that they must be allowed to withdraw the proceedings in Calcutta, and the Supreme Court has dismissed both those. Okay.
Well, let me get Mr. Ranina in on this. Ranina, you've long been a veteran of cases of the Reserve Bank trying to help banks to get their assets back faster, assets of defaulting promoters. How would you rate the importance of today's judgment, sir? Does it further the case of the IBC and therefore the robustness of the banking system getting its assets back? Okay. I think we will have to reconnect with Mr. Ranina. Rajendra, the same question to you. You watched this process, I think, from the DRT days and definitely through the SARFACI Acts. Is the court's judgment today telling you something about the judicial system's commitment to getting the IBC process on without hitches?
Well, absolutely. I think this is a very important message that you cannot have two tracks, and you need to preserve the integrity of the process through and through. And therefore, once you are into the resolution plan era, you need to go only through that process. And you cannot have an alternative mechanism to negotiate out of that process. Okay. So it's a very important milestone to my mind.
Well, Suharsh, what would you take away from the judgment? I think Mr. Shroff and my colleague Ashmit have detailed in as much detail as possible what they heard from the court. What will your key takeaways be as to what the judicial system is saying about the process?
Sure. No, I concur completely with Mr. Shroff. I think this is a very landmark judgment, because the IBC lays out a time-bound process for resolution of companies with very specific milestones in that time zone. There are a lot of checks and balances put in place so that there is procedural fairness for all parties involved. Moreover, the Committee of Creditors, in most cases, they come up with a very objective evaluation matrix. So even in the Binani case, the IRP, in consultation with the Committee of Creditors, had come up with a very objective and transparent evaluation matrix. And all the bids that were submitted were subjected to that matrix, and a ranking of weightage was given to each bidder. At the end of that process, if one person comes out as the winner, then that should be respected. I think there was some scope for doubt, because a few months back, the Supreme Court observed in a couple of cases, including, I believe, Lokhandwala, Kataria, where Supreme Court said that an out-of-court settlement can be done, but that was under Article 142 of the Constitution, which talks about inherent powers of the Supreme Court of India. The question was whether that precedent will also be used in this case or not. I think there was general consensus that the Supreme Court, when it used 142, that should not have any precedential value when it comes to general IBC cases, because in that case, a one-on-one settlement was allowed between a particular creditor and the company. So coming back to this case, I think the Supreme Court has taken the right view, and this preserves the sanctity of the process and the integrity of the process. Okay. I believe that the H2 over here, the second bidder, later on upped the bid by a few hundred crores. But I think just because the second bidder ex post facto has raised the bid, that should not vitiate the fact that the first bidder won the process in a very fair and transparent manner.
Fair. Okay, I think we have Mr. Ranina in. Mr. Ranina, I don't know how much you could hear of Shardul Shroff's detailing of what happened today in the court, as well as my colleague Ashmit. But tell us, sir, what are your key takeaways? You have seen the judicial system's response to the previous SARFAESI and DRT, and you have seen its response to the various challenges that have come to the IBC. What would your key takeaways be in terms of the judicial system's response to the IBC process?
My key takeaway is that this is a pure interpretation of the IBC law. You know, different laws have different interpretations, but IBC has been given a specific interpretation by the Supreme Court in this particular case. Okay. So really what they've said is that once the process has started, you cannot go back on it, because otherwise, you know, people in future will lose faith in the very process. Okay. Because if everybody, you know, votes a bid and then somebody goes and makes an out-of-turn settlement, then the whole process is vitiated. So this cannot be permitted. I think it's a correct judgment that will have a salutary effect on the insolvency process as such. Okay. Thanks for that, gentlemen, for your initial comments. There are still, of course, issues that can kind of ambush or disturb the smooth flow of the IBC process. There have been times when the Committee of Creditors has been expanded retrospectively, and therefore a rebidding has been allowed in a specific case. Rebidding has been allowed in other cases as well. There can be the behavior of the IRP, which is different in different cases, since the institution is just evolving. What can destabilize the process, and what should we beware of? That's the question I want to ask my panel in a minute. We've just had the judgment from the Supreme Court in the Binani UltraTech case, where the court has unequivocally said that the integrity of the highest bidder shall be preserved, and out-of-court settlements by the second bidder cannot be considered sacred. In fact, they've almost dismissed that plea and sent it back to the NCLAT. We've been speaking with Shardul Shroff, Rajendra Chitale, Suharsh Sinha, and Mr. H.P. Ranina. Well, the second question I have is, how can the process be improved upon? Rajendra, your thoughts?
I think this is a good beginning. At the same time, we need to figure out a framework, and this doesn't require a change in the law, by which we will be in a position to create a tension amongst bidders, at least in cases where a uniform set of conditionalities can be arrived at, so that thereafter we can follow the kind of process which has been successful in other auctions, where you don't have just one H1 who is declared once and for all, but there is, once you have selected a set of participants who qualify and you set certain common parameters, then on that you can actually have a process where between them they compete to, in effect, bid for a higher amount which can be recorded by the lenders. Okay. So I think this needs to evolve. Okay. Well,
Mr. Shroff, would you agree? My only fear with the suggestion made by Rajendra is that each case is so terribly unique. Will we be able to arrive at a common set of conditionalities? And secondly, the time value of money, as it is, we have seen the banking system battle with loans, bad loans, which are 4 or 5 years old. And therefore, if we try to fine-tune the process too much, will we lose? Your thoughts, Mr. Shroff?
I respectfully disagree with my friend Rajendra that you can have a principle where you bring in an auction route after you have a technical qualification. The structure which has been presently put in place with most of these resolution processes is that an evaluation matrix which was sort of introduced on the 6th of February into the rules, is set up between the COC and the resolution professional, and a unique marking system which is publicly disclosed is made available to all the bidders, so everybody knows exactly how they would be evaluated.
Okay.
Now the law as it is emerging is quite clear that you have to put your best bid forward on the first day. You cannot have a second bite at the cherry. If you lose on the first bid first time, then you have to gracefully exit. You can't go on asking for a second and a third round. This is the process which has been established by today's decision. It is not a judgment, it is really an order, because a judgment would require a full-fledged reasoning.
Okay.
In this particular case, all that they have said is case dismissed or case withdrawn, but it restores the NCLT order, which basically had given a direction to NCLT to decide this matter without being influenced by the observations either of the NCLT or of the NCLT of seeking an out-of-court settlement.
Okay.
So the court, by this deductive process, effectively saying, don't look at out-of-court processes, just decide this in accordance with the IBC.
Okay. Well, you get half a minute to come back on it. We have to get to the other issue.
Sure. I think this needs to evolve, because eventually this is a phase where only time will tell whether this is the best way of doing things or there are alternative ways which needs to be tried out.
Fair point. And of course, these are, a whole complex of cases. Mr. Ranina, I want to come back to you on the broader issue. Until now, the courts, even in previous cases, even where they have given a hearing, have not stopped the NCLT process, which means that the judicial system has respected the fact that it has to get over in 180 days, at best 270 days. Do you think something can destabilize this? Do we need, say, a code of conduct for the IRP, something wrong, something corrupt that the IRP may do, which might kind of shake the judiciary's confidence in the process? What should we beware of?
No, I think this is a ongoing work in progress. So long as this process is going on in the usual form, I think it will be allowed. If there are some hitches, if there are some problems, maybe in course of time in the next couple of years, they will be sorted out at the legislative level. But at this point of time, I think this system should be allowed to function. It must have a reasonable 2 to 3 year period to stabilize itself and become a very important part of our judicial process and judicial system. So I think we should not interfere at this stage. We should not tinker with it, allow it to settle down. And if after 3 years, if something needs to be amended, certainly we should look at it.
Okay. No, Mr. Ranina, I'm asking you because you as a member of the Reserve Bank Board and I as a banking reporter have seen several previous attempts. I think every decade there has been one attempt, and I come back to it, the DRT in the 90s, the SARFACI in the 2000s, have all been, have all been impeded in some way, with the courts having to play a role. This time, do you think the courts are respecting the timetable better, and should we therefore take this as an indication that the IBC process will deliver the goods?
Yes, I think so. I think for the first time, the Supreme Court is giving due credence to this to the legislative requirement of the time limit. In the past, sometimes they have the judges themselves have not, adhered to it. But this time, I think they are very serious, because they feel that insolvency proceedings have a certain important role to play in the economic affairs of a country. And if you want India to be a good, investing destination, then this process has to be strengthened. So I think they're going out of their way to make sure that this is now going to be adhered to, so that you send the right signals to foreign investors.
Okay. Well, very quickly, Suharsh, running out of time, any do's and don'ts that can be prescribed for the insolvency professional so that the process goes on in this time-bound fashion?
Sure. So I think we're giving too much importance to the IP in how the bids are selected and what bids get ultimately voted on, because the evaluation matrix is decided by the bankers. The voting, the sole prerogative of choosing a plan lies with the committee of creditors. The IP's main focus should be running the company as a going concern. I think the IP is saddled with far too many responsibilities. He has to run the company as a going concern. He has to act as an investment banker and sell the company. And at the same time, make sure that there are no legal uncertainties, there are no legal issues in the whole process. So I think his main task is to make sure the company is run as a going concern. And the IP, I believe, is already under a lot of scrutiny. He's subject to a code of conduct. He is regulated by the Insolvency and Bankruptcy Board of India. And there are certain punishments and fines prescribed in the IBC in case he acts in a malafide manner. So I think the IP is not really the real focus of attention as far as I can see it. It's more on the committee of creditors and how bankers make up their minds as to what is the best evaluation matrix and what is the best process they want to follow for every case.
Sure. Any advice to the committee of creditors then to ensure that the process doesn't go beyond the 270 days?
Well, I think as we go along, if we are able to refine it in a manner that we get it right financially as well as legally, that's the #1 agenda I think we need to achieve.
Okay. Yeah. Well, final thoughts from you, Mr. Shroff. Do you think we now have the judiciary's blessings fully for the IBC process? And any advice, yet again, like I asked Rajendra, for the committee of creditors?
I think one area which I would certainly like to comment upon is the interference by the high courts or by the NCLT at the stage when the process is ongoing. The aspect that you challenge whether or not the IBC itself is or the CIRP is maintainable, issues in relation to eligibility. These are issues which impede the process, and then ultimately the NCLT and the courts have to search out a principle as to whether the time taken by them should be excluded from the 270 days or the 180 days. I think they need to be fast and quick in their decisions. You can't be sitting over a matter for 2 to 3 weeks. You cannot be, letting admissions take. I've had a case where an admission has taken 5 months. So these are some things which are completely antithetical to the proceedings and the timelines which are prescribed under the IBC. There is a lot going well for the IRP, a lot going well for the COC, but the NCLTs themselves have to discipline themselves in terms of disposal, in terms of the time that they give for arguing admissions. It's not a trial.
Yes.
But the NCLTs are almost conducting a trial before admission.
Fair point. I think you'll have summarized it excellently. I don't have to repeat. Thank you very much, gentlemen, for joining me in this extremely erudite discussion.